Well, good morning, everyone. This is George Spees from the Pennsylvania Office of Open Records. Welcome to this morning's webinar, where we're going to be talking about laws that protect information. Hope everyone had a nice holiday weekend and that you're gradually easing back into the swing of things, getting ready for the fall push. This webinar is being recorded, and the recordings are saved to the OOR's website. So if by chance, let's say you have a colleague who wasn't able to attend this morning, in a couple days, it'll be uploaded to our YouTube channel, and then a link on the website will connect to it so that you'll be able to go to the website and review the webinar for any future use, localized training, or maybe just for your own edification to have it available to refresh your notes. Also, if you've ever attended these webinars before, you know that it's essentially a PowerPoint presentation with me talking in the background. That PowerPoint, as well as all of the PowerPoints that we use for our training, are also available on our website. And you can go to the training tab, scroll down, and you'll find them there. And again, the same conditions apply. If you need to download it for any reason, whether it be for localized training, other staff that couldn't attend today, or your own reference, feel free to do that. I mean, after all, they are public records available for your use. I think that takes care of most of the preliminaries. So let's just jump right into the webinar itself. Oh, I know. We need to talk about questions. Sorry about that. As we're proceeding through the webinar, if something comes up and you have a question, feel free to type it into the chat feature, and I'll do my best to answer the question live as we're proceeding. I have, two requests for you, though. First is, we're talking about laws that protect information. So let's stay on topic and limit our comments and questions to that. Secondly, if you can keep your questions as brief as possible, and it's mainly for practical reasons. It's just awkward for me to sit here and read several paragraphs that someone may type in while everyone else is waiting patiently. If by chance, your question is unusually complex or specific to your particular situation, we'll do one of two things. We'll wait until the end of the presentation, and I'll do my best to come back to it, or we'll take the conversation offline. Contact for the information is on the screen right now, our office phone number and the URL for our website. On the website, we have email accounts that you can use to submit your questions. They first come into our administrative staff, who are very well versed on the right to know law and can typically help you out. If you happen to stump them, however, your question will get escalated to a member of the senior staff. And there we do our best to get back to you within 24 hours, because we figure, if you're contacting us, number one, it's important. Number two, is probably time sensitive. And we're pretty good about getting back to you in a timely manner. So again, feel free to enter your questions in the chat feature, or at any time, feel free to reach out to the office with any questions that you might have. We can't write requests for you. We can't respond to requests for you. And we can't provide any legal advice. And we can't discuss any active appeals. But we can steer you towards rulings that we've made where the facts are very similar to whatever you might be presenting. So we typically are able to steer you in the right direction. Okay, I think that takes care of all the preliminaries. Let's jump into this topic. And the first thing we want to do is, explain why we believe this webinar is important. And there are a couple of reasons, but I think an important one is that other laws can remove the discretion that exists within the right to know law. Okay. If you're familiar with the right to know law at all, usually people refer to Section 708B, where that lists the 30 exemptions. And as I talk about in the basics course, a lot of people mistakenly think that the right to know law is a confidentiality law. that those exemptions, which define types of records that can be withheld, actually mean they must be withheld, which is not the case, okay? The right to know law exclusions are discretionary, meaning that even though a record may clearly fall within the definition of an exemption, the right to know law doesn't say you have to withhold them. They say you can withhold them, which also means you can release them if you feel inclined to do so. But through this webinar, we explain that most of the other laws that include confidentiality provisions are not discretionary. Rather, they are mandatory. And they say that you must withhold any record that falls within this area of confidentiality. Furthermore, we refer to Section 306 of the Right to Know law, which, to paraphrase, nothing in this act shall supersede or modify the public or non-public nature of a record or document established by federal, state law, regulation, or judicial order or decree. Okay, translating that to English, what it basically says, if there is another law that deems a record confidential, that law supersedes or trumps the right to know law. And usually, like I said, those laws are mandatory, not discretionary. So those laws take precedent over the right to know law. Now, moving forward, another important reason as to why this webinar is important is, if you remember, the agency, not the citizen, but the agency bears the burden of proof to show why a record should not be released into the public domain. So again, typically they would refer to one of the 30 exemptions in Section 708B of the Right to Know law. But if there is that other law that says a record is confidential, they can use that reference in supporting their burden of proof. Okay, so you can use the confidentiality provisions of another law as well as the right to know law, if the two coincide, to meet your burden of proof in showing that this record should not be released into the public domain. And let's say it gets appealed, it's used as the initial response, and the requester disagrees, so they file an appeal with our office. Well, when that legal case is made by the agency, they can cite these confidentiality provisions in the other laws, and the appeals officer will weigh that. They'll familiarize themselves with that law if they're not familiar with it already, and those other provisions have been used to support the agency's right to withhold those records. Okay, so let's talk about some of the more common laws themselves. And before we do that, I want to apologize for the lack of continuity. What we've done here is take a look historically at what other laws most frequently are used by agencies to support withholding records from public release. So they kind of bounce all over the place, but I've done my best to more or less, organize them as best as possible. But we are going to bounce around quite a bit here. But let's talk about the first one, and probably the one we see the most, which is the Criminal History Records Information Act of 1980, or what's also referred to as CRIA. Now, CRIA applies to any person or agency that collects criminal history information, such as police departments, prisons, district attorneys, sheriffs, courts, just to name a few. Now, CRIA and its confidentiality provisions protects criminal history, investigative, and intelligence information. And essentially, this information can only be shared with other certified law enforcement agencies as defined by CREA. Okay, now that's important because there are other laws that have definitions of law enforcement that vary or that are different from how CREA defines a law enforcement agency. A quick example in that Act 22, which governs public release of dash cam, body cam, and security camera footage collected by law enforcement agencies. There, under Act 22, believe it or not, a school district, or for that matter, a charter school, could be considered a law enforcement agency. Under CREA, that's not the case. Law enforcement is more of a what do I want to say, a typical understanding of what a law enforcement agency is. You know, uniformed or law legal entities, as opposed to something like a school district. Okay, so information can only be shared among traditionally understood or what are understood to traditionally be law enforcement agencies. I'll give you a good example as to why this is important. Within the right to know law, you've got exemption 708B16. Okay, it covers criminal investigatory records. Okay, what it does not cover is intelligence information. Okay, there's no reference to police intelligence information in the right to know law. So let's say that a police department keeps a file on suspected gang activity within their jurisdiction. Okay, that file is not protected by the right to know law, couldn't withhold it. But if I go to CREA, there is a specific reference to police intelligence information. So if someone were to submit a right to know request for a copy of that file, the police department would withhold it, citing the confidentiality provisions, not in the right to know law, but in CREA. And CREA makes it mandatory. CREA will actually sanction anyone for releasing information that should not be released outside of the universe of law enforcement. Now, a very good guide for CREA can be found on the Pennsylvania Attorney General's website. Okay, and they have individuals over there who are well versed in CREA, who I would use as a source for expert advice. So I would recommend first, take a look at the handbook. You can download it for free, very good resource. And then if you have further questions, feel free to reach out to them. And my experience, it's been a couple of years now since I've contacted them, but they've always proved to be very helpful. And again, we'll get you steered in the right direction as to what you can and cannot do using CREA. Okay, a related law is Act 30 of 2016. This applies to your 911 centers, or what Act 30 refers to as public safety answering points, emergency call centers. Okay, and I always refer to them as 911 centers, but you still find local police departments that have some limited dispatching capabilities. Maybe during the day, they will local dispatch and then at night turn it over to the county 911. Some 911 centers cover multiple counties. Act 30 covers it all. If you've got a law enforcement agency or some entity that is responsible for receiving emergency calls, they're covered by Act 30 because those call centers are fall within the definition of a public safety answering point. Act 30 protects any individual identification information that would include callers, witnesses, and victims. And that identification information, at the very least, it includes the names of people who are calling in or who may be a witness or a victim, the telephone numbers, and the home addresses are protected. Now, under the right to know law and associated case law, home addresses are protected. But Act 30 goes a step further. Actually, it predates a lot of the case law with the right to know law and ensures that home addresses are not given out when someone calls a 911 center requesting information. Okay. Now, it will not protect the location of the address unless it would compromise any of the information that we've talked about, that individual identification information. Usually what 911 centers will do, okay, now when they dispatch, they give out the information, the address, so that the police department, fire department, ambulance, whatever, knows exactly where to go. But a lot of that is not accessible to the public. It's only accessible to the emergency services. But if someone calls in, let's say a citizen is curious about, hey, what's going on down the street, the 911 center will not give out a specific house number, but they can give out like a block number. For instance, I'm sitting in a building that's known as 333 Market. If there were an emergency here, the 911 center could release that, okay, it occurred at a building at 4th and Market Streets in Harrisburg. Or they'll use the 300 block of Market Street. Okay, they'll give cross streets, block numbers, or if it occurred like out on the interstate, they might give the mile marker, but they won't give a specific street address if there happens to be one, like with a state route that also has mile markers. That way, they're not giving out the specific home address because the courts have ruled that under the constitutional right to privacy, home addresses are considered confidential information. So Act 30 protects all of that. And occasionally we will get calls from 911 centers. Hey, what information can we and can't we give out? And I'll refer them to Act 30 specifically. And occasionally, well, it happens more than occasionally, people will call their county, they'll call the fire department, they'll call the 911 center itself asking for information. And this law prevents them from giving that information out. And the same standard would exist for any right to know requests that are filed with these entities for specific information. It's all protected by Act 30. They cannot give it out. Okay? Switching gears, moving on. This one also comes up frequently, attorney-client privilege and work product. Okay, now this is a concept in a law across the board that anytime an attorney discusses sensitive information with one of their clients, that information is covered by attorney-client privilege and it cannot be released. This is part of the rules of evidence in Pennsylvania, and it's supported by statute. It's also referenced in Section 305A2 of the right to know law. But attorney-client privilege essentially protects any communication between lawyers and their clients involving legal advice and strategy. For our purposes here with the right to know law, we're talking about municipalities and their solicitors. And when I say municipalities, we're talking about cities, boroughs, townships, school districts, authorities, and the like. Any government entity that would typically be covered by the right to know law and their solicitors, whether it be an in-house solicitor or someone on just a private law firm on retainer, chief counsel, however you want to define it. Any legal advice provided to the counsel, the supervisors, senior management would be protected by attorney-client privilege and cannot be given out. Okay, now the question comes up about invoices because this is probably the most common right to know request we see where attorney-client privilege might be raised. And it all comes down to how detailed the invoices are. People file a right to know request. They want to know, how much their township is paying their solicitor for legal fees. Well, if the solicitor only puts down, like for this month, I'm charging you X number of billable hours, and here's my bill. Okay. That does not contain any sensitive information and thus would be considered a public record and could be released or should be released under the right to know law. But if by chance the solicitor goes into greater detail, and I'll just give you a quick example. Let's say that for this month, I'm charging you 9 billable hours for research I did on this body of case law relative to the court filing by this company who's suing the township. Okay. And another 3 hours to depose, or not depose, but to um, solicit witnesses who we're going to use to testify on our behalf. Okay. Now there, you can kind of get a sense of the legal strategy that the solicitor is going to use on current litigation. So in that instance, you could possibly argue that because the invoice goes into such detail, it's protected by attorney-client privilege. All right. Now, if you don't know, if, this is obviously it's subjective. If you don't know, our recommendation is go talk to your solicitor directly and get their opinion. Do you think your invoice would be considered covered by attorney-client privilege? If they say yes, then withhold it. The requester always has the option to appeal it. And our office has been given the authority by the Supreme Court to rule on whether records are protected by attorney-client privilege. And we have, supporting cases within our final determinations database on the website. You can go in and search on legal issues. One of those legal issues is attorney-client privilege, and it will bring up all of the rulings our office has issued since 2010 that involved attorney-client privilege, and you can get a good read on where our office currently stands on all that. Okay, so like I said, this comes up fairly often, so it's something you should be aware of, whether you're a requester or whether you're an ARO working for a municipality. All right, jumping around again, here's another one that frequently comes up. It's the UCC, or the Uniform Construction Code. The code is essentially the statewide building code, and it applies to any agency that possesses building permit applications, plans, and associated records. Okay, the UCC, looking at its confidentiality provisions, it specifically protects applications, the building plans, the specifications, inspection reports, and similar documents. Okay, that language is pulled right out of the UCC. And it applies for buildings constructed after 2004. Okay, why do we have that date? Well, that is the date that Pennsylvania adopted the UCC as its building code. Prior to 2004, you're going to have to do some research and find out what was the building code used by the municipality before the UCC was adopted. And I'm old enough to remember some municipalities used the Life Safety Code, others used BOCA code. Some municipalities had their own local code that they compiled. And if you were a developer or a builder, it was a real nightmare for you going from one municipality to the other, having to know, okay, what codes apply here but don't apply there and the like. And then you'll need to see, looking at those codes, what, if any, confidentiality provisions existed. Okay. Now the building permits themselves, okay, those are public records, okay, and because they involve addresses, a building permit isn't worth much if you're not able to give out the specific address for a commercial dwelling. So yeah, you can give those out, and you can give out the address that the building permit applies to. Okay. Now, this is kind of interesting. There's a misunderstanding that the UCC only applies to commercial construction. Okay. But our office, way back in 2012, ruled that the confidentiality provisions of the UCC also apply to residential structures. And this predates a lot of the case law coming out of the Commonwealth Court and the Supreme Court that ultimately ruled that home addresses, for the most part, are considered confidential. Our logic was not in what the UCC says, but rather what it doesn't say. All throughout the UCC, it distinguishes between commercial dwelling or commercial structures and residential dwellings. Until you get to the confidentiality provisions, then you don't find that language. So the appeals officer at that time took that logic and ruled that under UCC, an agency can withhold building permit applications and building plans and other related records for residential structures, okay? The confidentiality provisions of UCC apply to residential structures. And, why wouldn't it? Because why would you give out the building plans for someone's home? Okay, it just doesn't make sense. Number one, why would someone request it for a legitimate reason? And number two, why would you give it out? Well, it turns out, occasionally there are legitimate reasons. And fortunately, the UCC also covers that. Under those confidentiality provisions, it says you don't give them out unless someone has a legitimate, basically need to know status. So for instance, if a homeowner wanted the building plans for their home, you could give them out. Same way for, a commercial dwelling. If you had a developer who was renovating a structure and they wanted the original building plans, and the municipality had them under UCC, because they have a need to know status, you can give those out. Same way with an owner, developer, anyone who has a need to know status. They can get those plans and the municipality can give those plans out. Now, any legal citations that lead to legal action, such as a building code violation, those are not given out per right to know, but they are accessible in Pennsylvania through what's called the 509 process with court records, okay? They're considered legal records, so you apply to the courts for copies of those legal citations and any associated records. Now, this does not apply to zoning, okay? Zoning boards are a different animal and they're covered by a separate law, the municipalities planning code. So you want to look at that law if you're curious about any records held by a zoning hearing board, okay? And that law governs what they can and cannot give out. All right. Moving on, let me get a sip of water here because we're going to get into the alphabet soup of health laws. Okay, first the one that comes up and probably the most commonly known is HIPAA, the Health Insurance Portability and the Health Insurance Portability and Accountability Act of 1996. Okay, this applies to healthcare providers for the most part, and it doesn't typically apply to employers. But nevertheless, there may be municipalities that find themselves in a position of being in control of health information. For instance, counties still may have county homes for the aged, senior citizen centers and the like. They may not directly control them, but they may control them through contract. In that contractual relationship will extend the county's burden over that privately or otherwise privately run facility because of that nexus between the historical role of the county in controlling a senior citizen center. Okay, it may or it may not exist depending on what sort of legal relationship is there. But nevertheless, I think it's important to know of the existence of HIPAA and the prohibition on giving out individual identifiable, or what we know as personal health information. Okay, so if the county is in possession of this, they cannot give it out, and they would refer to HIPAA in meeting their legal burden for not doing so. Now, an employee of a municipality can approve the release of health information to an employer, but then obviously the employer must keep it secure. Okay, so if just to paraphrase this, if a municipality has an employer, and that under HIPAA, if the employee voluntarily tells the employer that they have a health condition of some sort, they can do that. But then the employer is bound under HIPAA to keep that personal health information secure. They cannot give it out to anybody else. And HIPAA includes sanctions that the employer could find themselves being fined for violating the provisions of HIPAA. Okay, another common health law that we need to be aware of is the Family Medical Leave Act, FMLA. Okay, this applies to employers, human resource leave administrators, and direct supervisors in a government setting. Now, HIPAA protects leave. Okay, that's the big thing with HIPAA. Leave or accommodation related records that could disclose the presence of a serious health condition. Now, before I worked for the Office of Open Records, I was the human resources director for a large state agency. And I remember when FMLA came out, and these were the two big things, okay? Leave information had to be protected, and you got into this whole thing about reasonable accommodations, okay? And it got fairly complicated. So FMLA covers all this. And again, under FMLA, an employee can voluntarily provide, and the employer as well, can provide medical information to a supervisor, but it's on a need-to-know basis, okay? Now, I like to use the seizure example. If you have an employee who, let's say, suffers from epileptic seizures, they can notify the supervisor that, look, I have epilepsy and occasionally I may go into a seizure. This is what's going on. This is what you should do. Okay, but then the supervisor can only release that on a need-to-know basis. Let's say that the employee does experience a seizure and 911 is called, the first responders show up. The supervisor legally can then notify the first responders, this employee has told me that they suffer from epileptic seizures. So that may be what's going on right now. Okay, completely within the legal framework of FMLA. They're allowed to do that. Okay, but they cannot broadcast it to anybody else without the employee's express consent. Okay. Now, the other aspect of FMLA that you should be familiar with is leave or records of absence. Okay, because under FMLA, the provisions, the employers keep or should be keeping a special log of FMLA related leave because you have a FMLA leave balance. this entitlement under FMLA. And once you exhaust that, then, bad things start to happen. But what happens is that if someone were to file a right to know request for a municipal employee's leave record, okay, because I'm kind of nosy and I saw this guy who works for the borough. He's been home for the last several days and he was out mowing his grass, and I just want to know if something fishy's going on. And this happens, so they file a right to know request. Well, by releasing the leave record, under FMLA, if you are using sick leave for 3 consecutive days, okay, technically the HR administrator or HR office should send a survey request to the employee asking them, was this absence related to a serious health condition, which, has its own definition under FMLA. So if you release the leave records, which show 3 consecutive sick days, potentially you could be inadvertently divulging the fact that this employee suffers from a serious health condition, which is why they were off. And bingo, you violated FMLA by releasing protected health information. So you want to be very careful about releasing any leave-related information. My recommendation is, when in doubt, withhold it. And, if the person feels compelled to file an appeal, they can, and let the appeals officer sort it out. But under FMLA, you need to be very careful about what, if any, leave information, what, if any, health information you release. Because number one, the chances of it being protected are very strong. Number two, if you should release it, the municipality could suffer sanctions, and you wouldn't want that to happen. Okay. Another health-related one, more current, ADA, the Americans with Disabilities Act. This does apply to most employers. It protects all medical records and requires that they're stored separately from other personnel-related records. Again, I was an HR director at the time. Prior to ADA, I could go over to, at this time, everything was paper-driven, so I could go over to a file cabinet, pull an employee's personnel jacket, and there would be health-related information in there. Okay, when ADA came down, our benefits staff created separate files and were under lock and key in separate file cabinets, to which I, as the they pay me to talk, as the HR director, I couldn't even access. Only the benefits staff could access. And it was, like I said, kept under lock and key in separate files. Okay, now, information can be provided by an employee voluntarily, but it would be as the result of a non-medical inquiry. For instance, I couldn't poll, as an employer, I can't poll my employees and say, hey, do you guys have any health conditions that I need to know about? But let me portray an example here where an employee can divulge health information through a non-health related survey. And it involves something we commonly encounter, building evacuation plans. Okay, let's say that the municipality in their building, they've appointed a building fire marshal. Okay, it's this person's responsibility to make sure that in the event of an alarm, that the building is evacuated in an orderly manner, and it's evacuated completely. So they poll the staff. Okay, and essentially they ask, do you require any special effort to evacuate the building in the event of a fire or, similar emergency? And an employee will respond back to the fire marshal, yes, I've had a double knee replacement. I have difficulty walking down steps, and, when the fire alarm is pulled, the elevators no longer work. Okay, so I can't evacuate the building because I'm on the 3rd floor. So the fire marshal makes accommodations. Okay, we're going to get you into the stairwell and you're going to hold in place on the 3rd floor landing, and we will notify the fire department that that is where you're at, and we'll have a deputy fire marshal stay there with you when the building is being evacuated. Okay, there, the employee has divulged the fact that they have a medical condition which now the fire marshal is aware of, okay? Again, on a need-to-know basis. So the fire department shows up, the fire marshal goes to them right away and says, I have an employee on the 3rd floor landing of the fire tower that you need to go evacuate. Okay, so the fire department does its thing. Okay, so you see how that all works. Non-medical related, the fire evacuation plan. Employee divulges the fact that they have a medical condition that they need help with. It's on a need-to-know basis. Fire marshal, assistant fire marshal, and then the first responders. Okay. In general, the other employees are not aware of what's going on unless the employee says it's okay. All right, but that's how that all works with ADA. Again, you need to be very careful about any medical records for your employees because under ADA, they are protected, and any information that's given out, either intentionally or by mistake, could subject the municipality to sanctions if a complaint is filed by that employee. Okay. Moving on, and we haven't had any questions here so far, so I hope everybody's understanding what's going on. Shifting gears again, now we're talking about school districts, and it could even involve universities for any students under the age of 18. But the law is known as FERPA, the Family Educational Rights and Privacy Act, which protects individual educational records. So it applies to public and private schools, which would extend to charter schools, primary, secondary, and post-secondary, okay, those colleges. So when we talk about individual educational records, yeah, report cards, transcripts, records of discipline, anything where an individual student can be identified. Which, okay, begs the question, well, what about when I look on a news website or the sports section of the paper and they're talking about, an individual student, who might be the local linebacker who's racking up, a record number of sacks this season. What's going on there? Why are they mentioning names when FERPA says you can't? Well, FERPA also has a provision in it that allows the release of directory information. And it covers, sporting events, the quarterly honor rolls, and the like, okay? So it's okay to release names under those provisions. Also, any aggregated data, okay? I can't tell you Johnny's grade, but I can tell you the average scores for standardized testing for a particular grade that Johnny happens to be in. All right, those aggregated reports are public records. However, if, and this has happened, if giving out the aggregated data, it can be, if it goes into such detail that it can be sliced and diced down to the point where you can identify Johnny and his grade, then you can withhold that aggregated data. And this may come into play like where you're identifying ethnic groups, okay? And let's say that the ethnic representation is limited, okay? So I know that Johnny comes from this particular ethnic group, and this aggregated data allows me to identify scores by ethnic group. And oh, look, there's Johnny, who's a member of this ethnic group, and Johnny's the only male. And here's the score for that particular sliced and diced cell. Then By doing that, I know Johnny's grade, okay? The district can withhold that aggregated data, and we've ruled in favor of that. And I'm not sure if that got appealed up to the higher level courts or not, but that's where we stand as far as our office is concerned. Okay. Now, something else that comes up with FERPA frequently is, okay, well, what about the grades for my child? Okay, well, under FERPA, there's actually a provision that allows parents or guardians to see the grades for their child. Okay, what happens though, unfortunately, is that someone files a right to know request for their child's grades under FERPA, using the provisions, the privacy provisions of FERPA. That's not a public record. So they deny the request, citing the privacy provisions in FERPA. But then what they fail to do is notify the parent that, oh, by the way, there are these provisions in FERPA where you can file a specific form and gain access to your child's grades. Shame on the district for not telling the parent that, because it usually results in a lot of headache and a lot of ill will with a parent. Okay, so if you're here today and you're a parent and you're having difficulty, you should know that under FERPA, individual records are considered confidential unless it's your child. Then FERPA has an internal mechanism that you can follow to get access to those educational records. Now, law enforcement, here we're talking about campus police for colleges. If you have a student who gets themselves in trouble with the campus police, those records are not covered by FERPA, although they may be covered by other provisions of CREA, which we talked about earlier, or they may be covered by the investigatory provisions in 708B16 of the Right to Know law, but they're not covered by FERPA. They're not considered educational records. Okay. And then there has been a flurry in the last couple of years on school videos and whether FERPA applies or not. Okay, there's a building, evolving body of case law. I wish I could give you a rule of thumb as to whether or not school videos are accessible or not, but the law is still evolving. We've got rulings where the courts have said clearly these videos are public given the circumstances. And then we have others where the courts have said in general they are not public. You have to phase out or fog out the faces of the students, okay, because they're protected by FERPA, but the incident itself is not, okay? The incident itself is not related to an individual educational record. So I'm gonna have to say, if you're asking me, are school videos covered? It depends. And I would take a look at our case law index on the OOR website and take a look at those cases where FERPA has been the issue and videos has been the issue, and just kind of sort it out for yourself where case law currently stands. Okay, and then clearly student health records are covered by FERPA. So, school nurse or like a physician or nursing assistant that may be in residence at a district, those records are protected. Anything that's kept, like a student who has to take medication daily, and only the nurse can issue that medication. Okay, well, they keep a record of that. Those records are clearly protected under FERPA as well as other laws. Okay, and then Pennsylvania has its own law, which is an extension of FERPA, the Pennsylvania School Code, which applies to public school employees and officials. Okay, they're responsible for enforcing this law, and it protects educational records, but then it also goes into greater detail on health records. where again, you have a school nurse or a nurse's assistant. The school code clearly states that any health records related to students as well as employees are confidential pursuant to the school code. Okay, shifting gears once again. Oh, shifting gears. See what I did there? The Pennsylvania Motor Vehicle Code. All right, this happens every now and then where someone files a right to know request. Usually they want to see a public employee CDL records, okay? Or they see a public employee operating a piece of equipment that they're thinking, he's not licensed to run that thing. You know, I'm going to file a right to know request to see whether the township even has a record of his license, you know. Well, under the Pennsylvania Motor Vehicle Code, license information is considered part of the individual's driving record, okay? And driving records, whether you're an employee or member of the public, whatever, are considered confidential, okay? And this is also covered under Section 708B6 of the Right to Know law, which covers license information, okay? But essentially, if you go to Section 6114 of the Pennsylvania Motor Vehicle Code, it says that individual driving records are protected, and a driver's license is considered the individual's authorization, part of their driving record to operate a vehicle. Okay, so any license information, whether it be, you know, whatever class you might be approved for, or if you have a CDL, all that information is considered confidential and it cannot be given out under the provisions of the vehicle code. Now, let's say you have an employee with a lead foot and they've gotten themselves into trouble with speeding tickets, or maybe they have some DUIs or whatever. That's a different animal, okay? Because then it becomes part of a criminal record, a criminal case. And again, if you want to see those records, you can apply to the courts under their 509 process, which is the court's equivalent of the right to know law, and you can usually gain access to those records because in Pennsylvania, under the Pennsylvania common law, court records are considered public records. So that's how you would gain access to see what's going on if you've got if you have a public employee who's gotten themselves into trouble, you know, in a driving related incident or series of incidents. Okay. All right. Another one that comes up periodically is copyright. Here I'm going to say we get more questions than actual legal appeals on this, but it's an interesting topic. And what it comes down to is a copyright is anyone claiming or using intellectual property in the form of authorship, meaning that on this particular record, okay, I am claiming that it reflects my original thought, my intellect, and I don't want anybody stealing my idea. So I'm claiming copyright, okay? Where this typically comes up in the world of right to know are building plans, subdivision plans, anything put forth by an engineer or an architect where they may claim copyright. Now, architect, you can kind of understand it. Engineer, not so much, because an engineer, anything that an engineer does usually has to follow standard industry practices. So if they deviate from that and claim original thought, they could, you know, they would need to be very careful about deviating from industry standards, because if something happens, they could find themselves in some sort of legal trouble, some sort of form of liability. So they want to be careful about that. But an architect, yeah, you know, it's possible they could claim original thought in, you know, maybe a design that they are submitting in response to building plans for some new structure that's going up. But that's difficult to do because a blueprint is a blueprint. And, a public building blueprint, like we said, under UCC, it may or may not be accessible. Usually under UCC, it's not, but, nevertheless, you want to be careful about this. Now, what happens though, and someone will submit a right to know request for a plan. And the ARRO or the codes person or whomever will pull these out and they'll see a stamp and they'll think, this is copyrighted, I can't give it out. Well, that first stamp usually isn't copyright. Rather, it's a stamp by the engineer or the architect that they have to put on plans to say, I am a licensed engineer or licensed architect. Thus, I am qualified to produce these plans. Okay. And that's all it is. It's just saying that whoever came up with these plans is qualified to do so and recognized by the state as a licensed architect or licensed engineer, so they can do this. If they are claiming copyright, typically, they don't always have to do this, but typically what will happen is they will affix a second stamp that represents the copyright rights, where they are saying, within this plan, there is original thought, and I don't want this given out to the public. Okay, so this comes up against the right to know law. How does the law treat this? Well, it turns out that there is case law. The law is the case is known as Ali versus the Philadelphia Housing Finance Authority. And I think we're talking about the Commonwealth Court here. But what the court ultimately said is that if the requester wants to inspect the record, meaning they just want to come in and look at the print, they're allowed to do so. However, they cannot have copies of the print as per the Federal Copyright Act. Okay, so you can look at it, but you can't have copies. Now, what if the person takes out a cell phone camera and snaps a quick picture? Okay, the municipality doesn't have to worry about it so much because any liability, any dispute is between the person claiming copyright and the person allegedly abusing the copyright. Okay, the municipality that's caught in the middle doesn't typically bear any liability. Okay, but obviously it's going to be analyzed on a case-by-case basis to see how this all works out. So again, it depends, but that's how the courts currently have ruled on all of this and where they stand. All right. Another one real quick here, Child Protective Services law. This may come up with a municipality that has a summer parks program. And you may have employees, you may have interns, you may have volunteers who come into contact with children as part of this parks program. Okay. Number one, they have to be approved through the Child Services Act. Okay. Child line clearances, criminal background check, and the like. You know the drill. Okay. All of that information is confidential. Okay. The municipality can release the fact that everyone is approved who is volunteering or who is assigned to this program. But let's say that one of those employees, one of those volunteers has a kid who has some unusual bruises. Well, under Childline, they are legally bound to report any suspicion of abuse, okay? They don't have a choice. They have to do it. So under the Child Protective Services law, any record of that reporting, any record of an investigation that may subsequently take place by Child, Youth, and Services, by the municipality, et cetera, is protected under this law and cannot be released, okay? And this gets into some touchy situations because, and we've encountered this, where you've got divorced parents and, you know, maybe there's a custody battle going on along with a report of abuse. Okay, so this kind of puts the municipality in the middle of an ugly situation. Unfortunately, and this is probably valid reasons, under the Child Protective Services law, you cannot release this information even to a parent. Okay, you know, it is the, I think the law states it best. It's to protect the child, okay? It's not to protect the parent, it's to protect the child. So when child, youth, and services come in, oftentimes, you know, they have to work with a heavy hand, and it's all for the protection of the kid, all right? And the municipality may find itself in the middle of an ugly, sticky situation, but you have to defer to what the law says. Do not give out any information related to an investigation into possible child abuse. Okay, just don't give it out, and that's the best way. You know, let the courts sort everything else out, and you'll be okay. All right, and then a related law, real quick, Older Adults Protective Services Act. This relates to elder care. Again, those senior centers that we talked about, it really only applies to employees and administrators. They are legally bound to report any suspected abuse. Any paperwork related to those investigations is protected. And here we're talking about elders over 60 who cannot protect themselves, okay? I was going to pull this slide a couple months ago, maybe a year ago, but then we got a couple cases through the Department of Aging where this was the law that was used. So we've kept it in. And, you know, these county centers obviously are distributed throughout the Commonwealth. So, you know, this is still an important and active law to use in response to right to know requests for this sort of information. Okay, this one, I'm not even going to talk about that much. It came up during COVID. Case law is basically saying any aggregated data related to health information can be released. The courts have pretty much said that the use of this law only applies to individual health information, not aggregated data. Okay, some miscellaneous provisions before we wrap up here. W-2s, okay? Under the Internal Revenue Code, W-2s are confidential. You don't give these out, otherwise you're violating the IRS provisions. It is surprising. People will file right to know requests for copies of W-2s. The reason is they want to know how much public employees are being paid. Okay, the pay information is public. W-2s are not. So you can satisfy that right to know request by giving out other records or just telling them, you know, how much an employee makes. Okay, but you don't give out the W-2s. Also, on the local level, you have the Taxpayer Bill of Rights, which makes it a misdemeanor to release any confidential tax information. That would include W-2s, employee filings, any pre-tax deductions that they may have as an employee, you would not give out. Any tax information that a municipality could come into possession of related to a citizen. Okay, you would not give out that confidential tax information. Another law known as LT, the Local Tax Enabling Act, same thing. It protects any information from any sort of tax investigation that a local municipality, tax collector, tax collection authority may come into possession of. Okay, you do not give out that information based on the confidentiality provisions of LT. And then finally, I've kind of referred to this, case law on home addresses and dates of birth, okay? Under the way case law currently reads, and it's evolving and it's expanding, but where it now stands is that for the most part, any home address or any date of birth, we're talking about the month and the year being public, but not the actual date, okay? That you would not give out under concerns for identity theft, okay? Uh, they're all confidential, okay? You don't give out the date of birth, you don't give out home addresses unless there is an overwhelming need for the public to be aware of that home address. Now, this has happened. Usually it comes into residency questions for public officials. Does this public official, in fact, live in the jurisdiction where they rule? There we have, our office has ruled that there the home address is public because there is a need to know as raised through the right to know process. But other than that, the law is in favor of the constitutional right to privacy of the individual, and the home address and the date of birth fall under that. Okay, this brings us to the end of the presentation. Haven't had a single question. I guess I've done a good job, or maybe everybody's asleep. But if you do have a question, now's the time to get them in. And if once we end the presentation, you have a question, like I said at the beginning, feel free to reach out to our office and we'll get you steered in the right direction. Okay, in the meantime, if you're typing a question, I want to direct you to our website. You've heard me refer to it a couple times. You're going to find all kinds of good information there. We've got the citizens guides, we've got the agency guides. If you happen to be an Arrow, you're going to find the Arrow guide, 78 pages, all kinds of good information in there. Download it for free. And go to the training page. You'll find opportunities for training, which we're very happy to do. And, we'll help you out any way we can. If you're a real geek for government transparency and you want to know what's going on, subscribe to our Twitter feed. Every morning at 7 a.m., we'll wake you up with all the news that's fit to print on government transparency for that day. Rulings that we've issued, court decisions, training opportunities that have come up. They're all being tweeted out there, and we're happy to let you know what's going on. Then finally, like I've been saying, phone number and URL for our website are on the screen. Talk to us, reach out, let us know what your concerns are, let us know what problems you're having, whether you're here from an agency or whether you're a requester that wants to know what's going on with the right to know law and you need help, okay? All right, everybody, we're gonna sign off. Oh, here we go. Regarding a police report that is not a criminal investigation in nature, missing toddler, would a non-listed parent be entitled to receive a copy of the report? Probably a custody issue. Mr. Stark, in that case, it's possible that the agency could invoke 708B17, which is a non-criminal investigation, okay? The courts have ruled that, well, first off, Ann, if it's a police report, then it's hard to say that it's not criminal in nature because, even though criminal charges aren't being filed, there is a potential that the police department could file criminal charges, which makes it a criminal investigatory action. So it's possible B16 could apply. But even if you decide, no, that's too much of a stretch, then it's possible B17 applies, a non-criminal investigation. So you could use that to withhold the record. And again, you're mentioning a possible custody issue. You don't want to get yourself in the middle of that, obviously, because then you could get hauled into court and, well, why did you release this information? You could say, well, we opted not to release it by invoking B16 of the right to know law. which is, within our rights to do. It's our standard practice, if you will. Missing toddler, you get into a potential mess there, even if it's not a custody issue. And the fact that it's someone under 17, you could invoke, I think it's B30 or B29, that involves a minor. So there are provisions all over the place that you could use to withhold information about someone who's not an adult. And I would err on the side of caution there, I think, just to keep myself out of a messy situation. Good question. Thank you. Okay. Getting ready to sign off here unless we've got some other questions coming up. I think we are done. Look, everybody, have a good day. Stay cool out there and have a good rest of the week. We'll be back in 2 weeks with our next webinar. So hope to see you then. Bye-bye.